All rise. This court is back in session. You may be seated.
Oh, you know what? I just realized I didn't call. Last minute technical issues. I didn't plug my computer in and the battery died on me. All right, a couple of things I wanted to go over and make sure that we're all on the same page, and that is we had a pretrial conference where the attorneys and I discussed one thing, and that is that my understanding that both sides have waived, or that the defendant has waived and the state has waived any requirement that the defendant, that the jury rather set the fine involved in the case. Is that correct?
That is correct.
All right. Second thing is that, where's my list of the three things? Oh, I'm sorry. Good. The second thing is that we agreed that it counts 11 and 12 of the indictment, that we are going to sever those counts for the record and have them considered by the jury after the conclusion of the initial trial. In other words, we're going to go through all of the trial process with all of the counts with the exception of 11 and 12, which, and the reason for that for the record has to do with the fact that the those counts are including language. Sorry, those counts are including language that involves a felon in possession of a handgun in the commission of a crime, and as a result of that, we're trying to avoid anything that might in some way influence the jury. So those two counts will be considered by the jury separately and apart than the first 10 counts after the conclusion of the jury's deliberations on counts 1 through 10. Once they reach their verdict, then we'll have another mini trial, so to speak, regarding 11 and 12 to ensure that there's no prejudice involved in having those considered. Now, the only other issue then is the swearing in of the additional jury officers. We have sworn in those that were present earlier, and we'll go ahead and bring in all of those who are jury officers that have not yet been sworn in. So they need to come in. All right, good afternoon, or good morning. We're going to go ahead and ask that each of you be sworn in, but before you do that, for the record, if you would each state your name and the agency of which you are a member so that the record is clear that you have been sworn in. Thank you.
Wayne Tiffel, Tennessee Highway Patrol.
Andrew Perez, Tennessee Highway Patrol.
Edward Dexter, Tennessee Highway Patrol.
Holly Melton, Dixon County Sheriff's Office.
Greg Howard, Dixon County Sheriff's Office.
David Elliott, Dixon County Sheriff's Office.
All right, and I'm going to ask you each to raise your right hand and be placed under oath by the clerk.
Do you solemnly swear to take charge of this jury, keep them separate and apart from all persons, not converse with them about the matters on trial, nor permit anyone else to do so, and return them again in open court on orders of the court, so help you God?
I appreciate the Highway Patrol's cooperation in this so that it eliminates some issues for us regarding that matter. But I would also urge you to make sure that the jurors are safe and comfortable and kept apart from anyone, and that no one attempts to influence them. So thank you. With that, we will go ahead and ask you to step out and resume your duties. Thank you. All right, anything then further before we bring the jury in and swear the jury?
No, Your Honor.
All right, we are ready for the jury. Oh, hold on just a second, please. Ladies and gentlemen, there are media that are here in the courtroom, and I want to address them for just a moment. This is a public proceeding, and I don't want to interfere with you doing your job, but by the same token, there is a certain requirement that we do require for the media guidelines, so to speak. There was a pool request or a request for a video camera that was submitted by one of the stations, and that first come, first serve is who has been allowed to have the pool camera, but any video that will be taken by the one video camera. The reason for that is to minimize the distractions that might be taking place if we had multiple cameras in the courtroom. If there were two media requests that, and who were they?
Well, there's 2 papers and 1 radio station request.
The court we can allow 2 still photographers under the Supreme Court's rules, and that would be on a first come, first.
The Tennessee Dixon Herald.
The Dixon Herald, and who else?
WDKN asked to take still photography with her camera.
All right. Anybody have any objection as long as it's done in a way that does not interfere with the proceeding?
No objection, Your Honor, as long as it doesn't.
All right. Whoever the media is, just as long as there's photography that does not show the jurors and is not distracting in any way, we'll be watching to make sure that doesn't occur, then we'll allow those photographs to be taken. Anything else then before we bring the jury in? All right, we're ready for the jury. And while the jury's coming in, I have informed them they are permitted but not required to wear facial coverings at any point during this proceeding. They're welcome to do so. They may change their mind about it once they see the configuration of the jury box, but other than that, that's entirely their decision. We have a little bit of copies. Ladies and gentlemen, welcome to Circuit Court Room number 5. I think this one is, in the Dixon County Justice Center. Thank you for your cooperation. At this point in time, we're going to go ahead and have you placed under oath for your obligations as a juror. So if you'll all stand, please, and let the clerk administer the oath.
Raise your right hand. Do you solemnly swear that you will well and truly try the issues joint wherein the state of Tennessee is the plaintiff and Stephen Joshua Wiggins is the defendant, and a true and just verdict rendered according to the law and evidence, so help you God?
Yes.
Thank you.
And you've given a copy of this to the counsel. We're going to give, there's 16, there should be one for each of them. Ladies and gentlemen, as I explained to you a moment ago, this is a fairly lengthy 18-page document I'm about to read to you. Rather than just assume you can hang on my every word and understand it, we're going to give you a copy of your own so that you can read along with me, and that way you will be able to better understand everything. So this will be yours for the future if you can keep it with you, or you can discard it however you wish. Everyone have their copy? All right, if you'll read along with me, please. Ladies and gentlemen of the jury, the defendant, Stephen Joshua Wiggins, is charged in count 1 in the indictment with the crime of false report. In count 2 in the indictment, the defendant is charged with premeditated first-degree murder. In count 3 in the indictment, the defendant is charged with first-degree murder in the perpetration of a felony. In counts 4 and 5 in the indictment, the defendant is charged with theft of property. In counts 6 and 7 in the indictment, the defendant is charged with criminal impersonation of law enforcement. In count 8 in the indictment, the defendant is charged with tampering with evidence. In count 9 in the indictment, the defendant is charged with arson. In count 10 in the indictment, the defendant is charged with abuse of a corpse. The defendant pleads not guilty to all of the offenses embraced in the indictment. Before we begin the trial, I would like to tell you a little bit about what will happen during the course of the proceedings. I want to describe basically how the trial will be conducted and what the attorneys, jurors, and judge will be doing over the course of the trial. At the end of the trial, I will give you more detailed instructions on how you're to go about reaching your decision. But now I simply want to explain how the trial will proceed. The law applicable to this case is stated in these instructions and those that follow, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out one or more of them to the exclusion of another or others, but should consider each one in the light of and in harmony with the others. The defendant has been charged by the state of Tennessee with a violation of state law. The document containing the charges is referred to as an indictment. An indictment is the formal accusation charging a defendant with a crime and is not evidence of anything. The defendant is charged in count 1 in the indictment with false report. For you to find the defendant guilty, the state must have proven beyond a reasonable doubt that the defendant knowingly made a false statement in response to a legitimate inquiry by a law enforcement officer concerning a material fact about an offense within the officer's concern, and with the intent to obstruct or hinder the officer from apprehending the person suspected of committing an offense. The defendant is charged in count 2 in the indictment with premeditated first-degree murder. The state must prove beyond a reasonable doubt that the defendant unlawfully killed the alleged victim, Sergeant Daniel Scott Baker, that the killing was intentional, and that the killing was premeditated. The defendant is charged in count 3 in the indictment with first-degree murder and perpetration of a felony. The state must prove beyond a reasonable doubt that the defendant unlawfully killed the alleged victim, Sergeant Daniel Scott Baker, that the killing was committed in the perpetration of or attempt to perpetrate the alleged theft of property, and that the killing was closely connected to the alleged theft of property and was not a separate, distinct, and independent event, and that the defendant intended to commit the alleged theft of property. If you find from the proof beyond a reasonable doubt that the defendant is guilty of murder in the first degree in either count 2 or count 3, then it shall be your duty, after a separate sentencing hearing, to determine whether the defendant will be sentenced to death, life in prison, without the possibility of parole, or life in prison. But you will not consider punishment for this offense at this time. The defendant is charged in counts 4 and 5 in the indictment with theft of property. For you to find the defendant guilty, the state must have proven beyond a reasonable doubt that the defendant intentionally deprived and knowingly obtained control over property owned by the Dickson County Sheriff's Office and Sergeant Daniel Scott Baker without effective consent. The defendant is charged in counts 6 and 7 in the indictment with criminal impersonation of law enforcement. For you to find the defendant guilty, the state must have proven beyond a reasonable doubt that the defendant intentionally and knowingly pretended to be a law enforcement officer for the purpose of engaging in an activity that is ordinarily and customarily an activity established by law as a law enforcement activity for the purpose of causing another to believe the person was a law enforcement officer. The defendant is charged in count 8 in the indictment with tampering with evidence. For you to find the defendant guilty, the state must have proven beyond a reasonable doubt that the defendant knew an investigation was in progress and destroyed or altered evidence with the intent to impair availability in the investigation. The defendant is charged in count 9 in the indictment with arson. For you to find the defendant guilty, the state must have proven beyond a reasonable doubt that the defendant intentionally and knowingly damaged personal property by fire without consent and to destroy for an unlawful purpose. The defendant is charged in count 10 in the indictment with abuse of a corpse. For you to find the defendant guilty, the state must have proven beyond a reasonable doubt that the defendant knowingly did physically mistreat a corpse in a manner offensive to the sensibilities of an ordinary person without legal privilege. The defendant has pled not guilty to the charges in the indictment. He is presumed innocent and may not be found guilty by you unless, after hearing all of the evidence, attorneys' arguments, and instructions of law, the 12 jurors seated in this case unanimously find that the state has proven its case beyond a reasonable doubt. The first step in the trial will be the attorney's opening statements. The state will tell you about the evidence it intends to present so that you will have an idea of what the state's case is about. This opening statement is not evidence. Its only purpose is to help you understand what the evidence will be and what the state will attempt to prove. After the state's opening statement, an attorney for the defendant may make an opening statement if they should so choose. Again, statements of the attorneys are not evidence. Next will be the state's case in chief, in which the state will present its evidence. The evidence in the case will most likely consist of physical exhibits, documents, and the testimony of witnesses. The witnesses will testify by answering questions asked by the attorneys. Venue of the offense lies in the county where the offense was commenced or consummated. If you find that the state has failed to prove by a preponderance of the evidence that this offense was commenced or consummated in Dickson County, Tennessee, then you must return a verdict of not guilty. After the state completes its case in chief, the defense will be given an opportunity to present evidence through witnesses and exhibits. A defendant is not required to put on any evidence or to testify. The burden is always on the state to convince you that the defendant is guilty beyond a reasonable doubt. If the defense does present proof, the state may then put on what is known as rebuttal proof. After the state's rebuttal, the defense may put on further proof. After you have heard all of the evidence, the state and the defense may present final arguments. I previously told you that opening statements by the attorneys are not evidence. Likewise, closing arguments are not evidence. In closing arguments, the parties will attempt to summarize their cases and to help you understand the evidence that was presented. The final part of the trial occurs when I instruct you about the rules of law that you are to use in reaching your verdict. After you hear my instructions, the final 12 jurors will leave the courtroom together as a group. You will then begin your deliberations to make a decision in the case. Your deliberations will be secret, and you will not be required to explain your verdict to anyone. Now that I have described in outline form the trial itself, let me explain the functions that you and I will perform during the trial. I will decide which rules of law apply to the case. My decisions will be reflected in my responses to questions and objections the attorneys raised during the trial, as well as in my final jury instructions. It is your job to determine what the facts are from the evidence. You must then apply the law and my instructions to the facts, and from that application you will arrive at a verdict. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden remains on the state throughout the entire case. Keep in mind that the defendant is presumed to be innocent of the charges against him. Thus, the defendant is not required to prove his innocence or to have his attorney make any statements or arguments or to produce any evidence. Reasonable doubt is that doubt created by an investigation of all of the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the offense. You, as jurors, must decide whether the state has proven beyond a reasonable doubt that the defendant has committed the crime charged in the indictment. You must base that decision only on the evidence in the case and my instructions about the law. Witnesses will testify in response to questions from attorneys. Witnesses are first asked questions by the party who calls the witness to testify, then the other side is permitted to cross-examine the witnesses. Although evidence is presented by asking questions, the questions themselves are not evidence. An insinuation contained in a question is not evidence. You should consider a question only as it gives meaning to a witness's answer. In addition, members of the jury may ask questions of the witness if desired. The procedure for a juror to ask a question of a witness is that the question must be written down and submitted to me. Do not put your name on the question, as the questions of the jury are required to be anonymous. If a juror has a question that he or she would like to have asked of a witness, that question must be submitted in writing while the witness remains on the witness stand. At the end of the witness's testimony, the jury will be excused, and I will consider the questions of the jury on the record. Then the jury will return to the courtroom. If the question is allowed by the rules of evidence, the question will be asked either by me or by one of the lawyers. You should not place any significance upon the fact that I asked the question of the witness or whether one of the lawyers asked the question. In either event, the question is being asked of the witness solely because it was desired by a juror. The wording of the question may be altered by me, or the question may not be asked at all. If the question is altered by me, you must assume that I had a valid legal reason for altering it, and you should place no significance upon this fact, nor should you draw any inference from it. I may refuse to ask the question at all. In that case, you likewise should place no significance upon this fact, nor should you draw any inference from it. An important part of your job will be making judgments about the testimony of the witnesses who testify. You should decide whether you believe what each person says and the importance of his or her testimony. In making that decision, I suggest that you ask yourself a few questions. First, did the person impress you as honest? Second, did he or she have any particular reason not to tell the truth? Third, did he or she have any personal interest in the outcome of the case? Fourth, did the witness have any motive, bias, or prejudice that would influence the witness's testimony? Fifth, did the witness seem to have a memory of the events he or she testified about? Sixth, did the witness have the opportunity and ability to observe accurately the things he or she testified about? Seventh, did he or she appear to understand the questions clearly and answer them directly? Eighth, was the witness distracted in any way? Ninth, how did the witness look and act while testifying? 10th, was the witness making an honest effort to tell the truth, or did the witness evade questions? And 11th, did a witness's testimony differ from the testimony of other witnesses? Another factor for you to consider in evaluating a witness's testimony is whether the witness's testimony during cross-examination appeared to be contradictory, unreasonable, or improbable. However, immaterial or minor discrepancies or differences should not affect the believability of a witness unless it should plainly appear that the witness has willfully. When a witness is thus impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it is corroborated by other credible testimony or by the facts and circumstances proved on the trial. As the sole judges of the facts, you must determine which of the witness's testimony you accept, what weight you attach to it, and what inferences you will draw from it. The law does not, however, require you to accept all of the evidence. In deciding what evidence you will accept, you must make your own evaluation of the testimony given by each of the witnesses and determine the weight you will give to that testimony. You must decide which witnesses you believe and how important you think their testimony is. You are not required to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding what testimony you believe, you should rely on your own common sense and everyday experience. There is no fixed set of rules you use in deciding whether you believe a witness. In making up your mind and reaching a verdict, do not base any decisions on the fact that there are more witnesses on one side than on the other. Likewise, do not reach a conclusion on a particular point just because more witnesses testified for one side on that point. Your job is to think about the testimony of each witness you heard and decide the facts. At times during the trial, an attorney may make an objection to a question that is asked by another attorney or to an answer that a witness gives. This simply means that the attorney is requesting that I make a decision on a particular rule of law. Do not draw any conclusion from the fact that an objection was made or from my ruling on that objection. My rulings only relate to the legal questions that I must determine and should not influence your thinking. If I sustain an objection to a question, the witness will not be permitted to answer the question. Do not attempt to guess what the answer might have been had the witness been permitted to give it. Similarly, if I tell you not to consider a particular statement that was made, you should put that statement out of your mind, and you may not refer to it in your refer to that statement in your later deliberations. In deciding this case, you may not draw any inference from an unanswered question, and you may not consider testimony that you're instructed to disregard. Any arguments about objections or motions are usually required to be made by the attorneys out of the hearing of the jury. Information may be excluded because it is not legally admissible. Excluded information cannot be considered in reaching your decision. A ruling that is made on an objection or motion will be based solely upon the law. You must not infer from a ruling that I hold any view or opinion for or against any party in this lawsuit. Some of you have probably heard the terms circumstantial evidence and direct evidence. These are the two basic types of evidence that exist in law. Direct evidence is direct proof of a fact, such as the testimony of an eyewitness. Direct evidence is those parts of the testimony admitted in court which referred to what happened and was testified to by witnesses who saw, heard, or otherwise sensed what happened firsthand. If witnesses testified about what they themselves saw, heard, or otherwise sensed, they presented direct evidence. Circumstantial evidence is all of the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all of the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. The court will not provide you with a transcript of the testimony at the end of the trial. Therefore, you must listen very carefully to the testimony. Each of you will be allowed to take notes during the trial for your own use during your deliberations. You are not required to take notes. Independent memory can be as accurate as written notes. You will be provided with paper and pen if you decide to take notes. During the course of the trial, you should not talk with any witness, defendant, or attorney involved in this case. Please do not talk with them about any subject whatsoever. You may see them in the hallway or on an elevator or at some other location. If you do, perhaps the best standing rule is not to say anything. Do not permit any other person to discuss the case in your presence. If anyone does attempt to do so, report this fact to the court immediately without discussing the incident with any of the other jurors. You should also not discuss this case among yourselves until I instruct you on the law and you start deliberating at the end of the case. It is important that you wait until all of the evidence is received and you have heard all of my instructions on the rules of law before you deliberate among yourselves. You must not communicate with or provide any information, photographs, or video to anyone by any means about this case. You must not use any electronic device or media such as a telephone, cell phone, smartphone, or computer, the internet, any text or instant messaging service, any chat room, blog, or website such as Facebook, MySpace, LinkedIn, YouTube, Instagram, Snapchat, or Twitter to communicate with anyone or to conduct any research about this case. During the course of the trial, there will be media reports in the newspapers or on TV or on the radio about this particular case. If there are, you are not permitted to read, watch, or listen to those reports. You as jurors must base your decision solely on the evidence you hear in the courtroom. You will receive all of the evidence you may properly consider to decide the case. Because of this, you should not attempt to do any research on your own or gather any information on your own that you think might be helpful. Do not conduct your own private investigation into this case, although you may be tempted to do so. Do not read any textbooks or articles concerning any issue in the case, or consult any other source of information. If you were to do that, you would be getting information that is not evidence. You must decide this case only on the evidence and law presented to you during the trial. Any juror who receives any information about this case other than that presented at trial must notify the court immediately. There are several rules concerning your conduct during the trial and during recesses that you should keep in mind. You will be a sequestered jury. You will not be allowed to communicate with anyone other than your fellow jurors and your sworn jury guards during the entire time that you serve on this jury. You will be kept together as a jury and separated from everyone else. You must not be outside the presence or supervision of your jury guards at any time. You must not speak to anyone other than your fellow jurors or guards at any time about any subject whatsoever. Second, do not discuss the case among yourselves during the trial. You must keep an open mind until you have heard all of the evidence, the attorney's closing arguments, and my final instructions concerning the law. Any discussions before the conclusion of this case would be premature and improper. Third, obey all instructions from your jury guards. They have been thoroughly instructed as to the proper procedure that must be followed. If they ask you to do something, there is a reason for it. Finally, during the course of the trial, I may have to interrupt the proceedings to confer with the attorneys about the rules of law that should apply. In some cases, we may have bench conferences in the courtroom outside of your hearing. And in some instances, I may ask you to retire to the jury room while we discuss a matter out of your presence. I will try to avoid as many of these interruptions as possible. We will try to resolve some of these things in the morning before we get started. I ask your patience because these interruptions are necessary points in the trial where we are to resolve legal issues. In the long run, they save time for all of us. If anyone needs a break at any time, please do not hesitate to ask. Simply raise your hand. If I do not see you, get the attention of one of your bailiffs who will advise me that a juror needs a break. Normally, I'll try to conclude the testimony of a witness before taking a break. The usual break times are at 10:30 in the morning and 2:30 in the afternoon, with the normal hour between 12 and 1 for lunch. If you need a break for any other time, please ask. A juror who is distracted is not paying full attention to the testimony. Both parties are entitled to your full, undivided attention to this case. This completes my opening comments to you. The next phase of the trial is the formal reading to you of the indictment in this case. This is the second day of August 2021. David Wolfe, Circuit Judge. General Crouch, you may read the indictment.
The grand jurors of Dickson County, Tennessee, duly impaneled, sworn upon their oaths, do present that on or about May 30th, 2018, in Dickson County, Tennessee, and prior to the finding of this presentment, Stephen Joshua Wiggins then and there did unlawfully make a false statement in response to a legitimate inquiry by Sergeant Daniel Scott Baker, a law enforcement officer. Stephen Joshua Wiggins provided Sergeant Daniel Scott Baker with a false Social Security number to prevent his apprehension for outstanding violations, arrest warrants in violation of TCA 39-16-502 and against the peace and dignity of the state of Tennessee. Count 2, the grand jurors of Dickson County, Tennessee, duly impaneled and sworn upon their oaths, present that on or about May 30th, 2018, in Dickson County, Tennessee, and prior to the finding of this presentment, Stephen Joshua Wiggins then and there did unlawfully, intentionally, and with premeditation kill Sergeant Daniel Scott Baker of the Dickson County Sheriff's Office in violation of TCA 39-13-202 against the peace and dignity of the state of Tennessee. Count 3, the grand jurors of Dickson County, Tennessee, duly impaneled and sworn upon their oaths, present that on or about May 30th, 2018, in Dickson County, Tennessee, and prior to the finding of this presentment, Stephen Joshua Wiggins then and there did unlawfully, feloniously kill Sergeant Daniel Scott Baker in the perpetration or attempt to perpetrate a theft in violation of TCA 39-13-202 and against the peace and dignity of the state of Tennessee. Count 4. The grand jurors of Dickson County, Tennessee, duly impaneled and sworn upon their oaths, do present that on or about May 30th, 2018, in Dickson County, Tennessee, and prior to the finding of this presentment, Stephen Joshua Wiggins then and there did unlawfully, with the intent to deprive and without consent, obtain or exercise control over Sergeant Daniel Scott Baker's patrol vehicle number 500, a Ford Explorer police cruiser, property of the Dickson County Sheriff's Office, and said property being valued more than $10,000 but less than $60,000 in violation of Tennessee Code Annotated 39-14-103 and against the peace and dignity of the state of Tennessee. Count 5. The grand jurors of Dickson County, Tennessee, duly impaneled and sworn upon their oaths, do present that on or about May 30th, 2018, in Dickson County, Tennessee, and prior to the finding of this presentment, Stephen Joshua Wiggins then and there did knowingly, with the intent to deprive and without consent, obtain and exercise control over the property of Sergeant Daniel Scott Baker, to wit, Sergeant Daniel Scott Baker's service weapon, a Glock 17 handgun, Sergeant Daniel Scott Baker's backup weapon, a Glock 33 handgun, and ammunition. Said property having a value of over $1,000 but less than $2,500 in violation of TCA 39-14-103 and against the peace and dignity of the state of Tennessee. Count 6. The grand jurors of Dickson County, Tennessee, duly impaneled and sworn upon their oaths, do present that on or about May 30th, 2018, in Dickson County, Tennessee, and prior to the finding of this presentment, Stephen Joshua Wiggins then and there did unlawfully and knowingly pretend to be a law enforcement officer for the purpose of engaging in an activity that is ordinarily and customarily an activity established by law as a law enforcement activity and causing another to believe that the person is a law enforcement officer. Stephen Joshua Wiggins made a radio transmission from Sergeant Daniel Scott Baker's patrol vehicle number 500 in response to a radio transmission from Dickson County Dispatch in violation of TCA 3916-301B12 and against the peace and dignity of the state of Tennessee. Count 7. The grand jurors of Dickson County, Tennessee, duly impaneled and sworn upon their oaths, do present that on or about May 30th, 2018, in Dickson County, Tennessee, and prior to the finding of this presentment, Stephen Joshua Wiggins then and there did unlawfully and knowingly pretend to be a law enforcement officer for the purpose of engaging in an activity that is ordinarily and customarily an activity established by law as a law enforcement activity and causing another to believe that the person is a law enforcement officer. Stephen Joshua Wiggins answered a cellular telephone call from Deputy Chris Lashley, Dickson County Sheriff's Office, while using Sergeant Daniel Scott Baker's agency-issued cellular telephone, and did pretend to be Daniel Scott Baker in violation of TCA 3916-301B12 and against the peace and dignity of the state of Tennessee. Count 8. The grand jurors of Dickson County, Tennessee, duly impaneled and sworn upon their oaths, do present that on or about May 30th, 2018, in Dickson County, Tennessee, and prior to the finding of this presentment, Stephen Joshua Wiggins then and there did unlawfully, feloniously, knowing that an investigation is in progress, did destroy and conceal evidence with the intent to impair availability as evidence in the investigation by setting fire to Sergeant Daniel Scott Baker's patrol vehicle 500, a Ford Explorer police cruiser, property of the Dickson County Sheriff's Office, in violation of TCA 3916-503, and against the peace and dignity of the state of Tennessee. Count 9. The grand jurors of Dickson County, duly impaneled and sworn upon their oaths, do present that on or about May 30th, 2018, in Dickson County, Tennessee, and prior to the finding of this presentment, Stephen Joshua Wiggins then and there did unlawfully, feloniously, and knowingly set fire to Sergeant Daniel Scott Baker's patrol vehicle 500, a Ford Explorer police cruiser, an automobile, property of the Dickson County Sheriff's Office, with the intent to destroy or damage said property in violation of TCA 3914-303, and against the peace and dignity of the state of Tennessee. Count 10. The grand jurors of Dickson County, Tennessee, duly impaneled and sworn upon their oaths, do present that on or about May 30th, 2018, in Dickson County, Tennessee, and prior to the finding of this presentment, Stephen Joshua Wiggins then and there did unlawfully, knowingly, and feloniously, without legal privilege, physically mistreated the body of Sergeant Daniel Scott Baker, a corpse, in a manner offensive to the sensibility of an ordinary person by means of setting the corpse on fire, in violation of TCA 3917-312, and against the peace and dignity of the state of Tennessee.
To that indictment, how does the defendant plead?
Your Honor, Mr. Wiggins pleads not guilty.
All right, not guilty has been entered. Then, does the state wish to make an opening statement? You may. Does this need to be on or off?